A very good evening and welcome back to my channel. To the subscribers of the channel, thank you very much for your support. I really appreciate those who are watching outside the club. Kindly subscribe and help me grow the channel. This is part 2 of the state's gravest weaknesses against the 5 accused. Today, I'm going to talk about the state witness management and strategic abandonment, perhaps the trial's most consequential. Procedural gap is the issue of abandonment, or selective omission of key state witness in particular. The failure to call any or most of the occupants of the house at the time of the murder remains a big problem. These uncalled house occupant witnesses equate to an elephant in the courtroom. The people present in the house at the time of Mayweather's murder formed the most immediate and potentially illuminating pool of first-hand witnesses. These individuals included Kelly Kumalo, Mayweather's then-girlfriend, Zandile Kumalo, her sister, their mother Ntombi Kumalo, Longwe Twala, Zandile's then boyfriend, Tumelo Madlala and Mithokozisi Twala, Mayweather's friends, and neighbor Ofiri. Critically, the majority of these survivors were not called by the state to the stand as witnesses in this phase of the trial. This omission left a huge impact. It gave the defense ample room to argue that those who know the truth best were not heard in open court, and that narrative gaps or contradictions about the order of events, identity of shooters, intruders, number of shots, etc. were left unresolved. This enabled persistent public conspiracy that the real mastermind or shooters were being protected, further fueling suspicion that the police or NPA investigations were compromised, whether intentionally to protect someone or due to incompetence. Is someone protected, or is it incompetence on the part of the system? The state's own central theory is undermined here, since critical elements such as who exactly fired the fatal shot, or how and when the supposed robbery escalated to murder remained matters of speculation and indirect. These then provided a strategic lifeline to the defense's inside job theory, contending that the murder was not a random robbery, but a planned hit, possibly with inside assistance. This alternative theory has not been directly tested by cross-examination of those present. The state itself conceded that any witnesses not called by them would remain available for the defense to summon, but in practice, logistical, legal, or financial barriers make such witness calling by the defense rare and logistically complex, especially in a case mired in acrimony and distrust of witness motivations or safety. Many people have lost their lives here. The defense moved formally, and in some cases repeatedly, to recall key state witnesses of particular note, such as police officer Sizwe Zungu, who had placed all 5 accused at the Vosloris hostel prior to the murder. Also, a critical linkage in the state's attempt to strengthen its narrative about premeditation and group planning. Defense attorney Charles Minizi pressing to recall Zungu and Msizi Jack Buthelezi for cross-examination, especially in light of delayed or incomplete disclosure of AVL vehicle movement data. The state resisted these recall attempts, demanding the defense justify expatiate on the reason for requesting the recall, while the defense insisted new evidence or late disclosure gave them a basis to pursue further cross-examination. The upshot is that procedural wrangling over witness recall absorbed additional time, fed arguments that the state was stonewalling vital re-examination, and allowed the defense to paint the efforts of the police and prosecutors as opaque and selectively protective. Why was it so difficult to allow Sizwe Zungu to be recalled? When it comes to evidence chain integrity and documentation, procedural lapses in the gathering and handling of evidence have been a hallmark of this case. Ballistics expert Chris Manjana, in testifying about the weapon and bullets, documented that evidence sometimes arrived at the laboratory in unsealed or open bags, raising questions about continuity and contamination. There was also testimony and defense challenge regarding missing cartridge casings at the crime scene, with explanations varying from possible jamming in the murder weapon to improper initial scene handling. There were disputes that arose over the validity of cell phone metadata that raised the possibility of fraud or evidence manipulation, pointing to discrepancies in phone numbers attributed to accused 5 physical. These gaps handed the defense a potent narrative. Not only was the evidence insufficient, but the state's record-keeping and continuity was so flawed as to cast doubt on the very integrity of the chain linking the accused to the crime scene and murder weapon. Ballistic and forensic evidence, supposedly the most objective form of courtroom proof, became a source of both state confidence and defense challenge. Mangena and corroborating expert testimony tied the 9mm bullet recovered at the scene to a gun once in possession of accused, Mthobisi Mncube. However, the ballistics analysis itself became a point of scrutiny, with defense attorneys questioning whether evidence was handled, analyzed, or stored correctly between initial seizure and subsequent expert review. Photographs of the firearm downloaded from a cell phone became the subject of courtroom controversy, with the defense accusing Brigadier Ginninda of misleading affidavit statements about the nature of the photo evidence and whether it was conclusive or merely opinion. Regardless of technical correctness, the perception of confusion, overreach, or poor documentation around forensics undermined public confidence and provided the basis for procedural challenges. Inconsistent witness testimonies, vulnerabilities in the state's narrative. The trial was replete with discrepancies and contradictions in witness accountings. Critical differences emerged between surviving house occupants, when they did appear, as with Zandile Kumalo and Ntabiseng Mokere, who gave differing versions about what happened immediately after the shooting and the order of events outside the home. Key forensic and crime scene testimonies, such as that of Sergeant Moshe, sometimes diverged from later state or defense expert reconstructions, especially as to sequence of shots, pathways inside the house, and forensic procedures followed. Cell phone metadata records offered by state witnesses revealed confusion over which numbers were whose, with different service providers, and data analysts testifying to competing last four digits, directly impacting the reliability, placed on call records as proof of collusion or conspiracy. Such contradictions were not fully fleshed out before the court, mainly because not all eyewitnesses were ever subjected to cross-examination, fueling the sense that the full truth of the evening's events remained elusive. Regulation of court process, Section 173 and Judicial Oversight. The judge's power to regulate proceedings, drawn from Section 173 of the South African Constitution, was tested repeatedly amid these procedural wrangles. In the face of repeated defense, accusations over the treatment of accused, especially Fisokule Ntuli, Judge Mogolheng forcefully asserted his authority to issue binding orders for transfer to alternative prison facilities if the smooth running of the trial was imperiled, citing the court's inherent power to regulate its own processes in the interests of justice. However, legal scholarship and recent case law emphasize that Section 173 powers are not unlimited. They extend primarily to the regulation of procedure, not the creation of substantive new rights. Despite some prisoner management decisions provoking disputes with correctional services, the judge's rulings mostly held, but at the price of heightened institutional tension and occasional further delays in actual trial proceedings, state case closure, timing, and strategic implications. After 3 years of evidence, the state closed its case in July 2025. This closure carried both legal and symbolic resonance. State prosecutor George Beloye, while closing, was at pains to emphasize that any witness not called by the state remained at the disposal of the defense. But in practice, this passing of the baton underscored earlier strategic choices. The state's decision not to call certain witnesses, notably most people in the House, left major holes in the timeline and chain of events the court was to rely on. The closure provided the formal opening for Section 174 applications and has seen the focus shift completely to the adequacy and integrity of the case thus constructed, rather than any forthcoming state revelations or smoking guns to come. Witness availability and subpoena challenges. Securing the presence of witnesses, especially as years stretched on and the case was repeatedly postponed or restarted, became a recurrent problem. The risk that vital witnesses would become unavailable through death, relocation, loss of memory, or threat perception was aggravated by earlier delays and by the prosecution's own pattern of not calling all immediately available surviving witnesses. Some witness unavailability was apparently procedural, as with the abandoned attempts to recall police officers or cellular analysts whose roles overlapped, but whose testimony diverged over time due to evolving narratives or loss of documentation. Ultimately, it is the efficiency and clarity of state case management that should be assessed as much as the defense's ability to exploit these holes. The conditions of the accused, particularly Fisokile Ntuli, formed their own procedural subplot. Repeated complaints about abuse, denial of contact with lawyers or family, lack of basic prison necessities, and security classification issues prompted court orders for transfers and further delays. Though correctional authorities insisted procedures were followed, and even accused inmates of gaming the system, the disputes further complicated daily scheduling and occasionally led to days lost in wrangling over side issues, rather than substantive progress. While many criminal trials experience hiccups and tactical surprises, the scope and persistence of procedural errors and omissions in the Meiwa trial are exceptional. Their collective effect has been to severely weaken the logical and forensic cohesion of the prosecution's narrative, to provide the defense multiple bases for both legal and public opinion challenges, not just over the substance of the charges, but as regards the fairness and legitimacy of the entire process, to erode public and victim family confidence in an eventual true justice outcome, regardless of the technical verdict. These failures are not abstract. They are instead tightly interwoven with the state's abandonment or omission of potentially crucial witnesses, especially those with the most direct knowledge of what actually happened in the house. My conclusion towards systemic lessons and the quest for justice. The Senzo Meiwa trial is, at root, a tragedy within a tragedy. The homicide of a national icon was compounded by a prosecution marred by avoidable procedural failings and tactical missteps. As of August 2025, the trial's conclusion remains uncertain, with the prospect of further adjournments, legal appeals, and possibly the acquittal of one or more accused under Section 174 looming large, solely as a result of these internal process gaps. Beyond the specifics of this case, the Meiwa trial's failings have revived national debate about systemic reforms. Should trial duration limits be legislated to avoid years-long proceedings? How can early standardized evidence and witness management protocols be enforced? What mechanisms might better balance the rights of the accused with the needs of justice in high-profile cases? The answers to these urgent questions remain for the nation's lawmakers and judiciary to deliver. Senzo Meiwa's case, meanwhile, stands as a somber warning. When procedural rigor and evidentiary completeness are sacrificed intentionally or not, even the most open and shut case can collapse under the weight of its own inconsistencies. The Meiwa trial, a would-be demonstration of national resolve and legal prowess, thus concludes, at least in this phase, as a cautionary tale that justice delayed and divided among the excluded and the untested is justice, at the final reckoning gravely endangered. Like, share, and comment. Thanks for watching. Bye.